Facts will be discernible from the memorandum itself, my lord. It is stated from
Yes,
page
sir.
F to K.
1 minute,
Facts
Mr.
are-
Consul, please.
We
1
will have
minute.
it. Oh, no, we can have it only.
Saturday.
No, 15 November.
I'm sorry.
November.
Grateful.
List it on 15th, right?
Yes, my lord, I must say, my lord, the threshold of my right as a freedom of expression, speech and expression, if I am in a public leader capacity, would be much higher. There is no doubt about it. A layman can say whatever he wants, and a leader may still not be able to say whatever he wants. But to judicially define that demarcating line would not be, my lord,
It will be
easy
difficult.
exercise.
And it has always to be related to the factual situation.
Factual situation. It will have to be subject to.
Actual situation, my lord, in Kerala case, my lord, has been indicated right in the judgment and even in the SLP, my lord, 3 instances. And after the instances, not only that he didn't deny it, he even reiterated it. He even justified it. My lord, that is a big problem. And similar situations occur elsewhere also. Therefore, this requires a deliberation.
Worships, in this particular case, the issue is fair investigation and balancing the right under Article 21, which is a fair investigation, and right to speech. So, Your Lordships, this issue has already been decided. We'll show it to Your Lordships, and Your Lordships will then examine it and lay the guide.
We will have it on 15th,
Yes.
right?
Yes.
List 15.
Yes. My lord, may I make one submission? 107414, I am the intervener. My lord, may ask, my name is not being shown, therefore I will have.
Show his name also.
Yes.
Bribe to vote in a particular manner in Rajya Sabha election. Earlier, there is a judgment, my lord, in case of P. Narasimha Rao, where, my lord, the court took the
I thought it is covered by.
It is covered, my lord, but the court said
It is how many judges?
Please to do 5 judges.
Five judgment.
majority, my
I
lord,
thought it covers, squarely covers Narasimha Rao's case.
yes, my lord, the court, my lord, while referring says this, the majority view, while acutely conscious of the seriousness of the offence, felt that the wrongful act and, within brackets, sense of indignation of the bench should not lead to a narrow construction of the constitutional provisions which may have the effect of impairing the guarantee to effective parliamentary participation. So, maximum leverage to be given, or the right of privilege should be read in its broadest possible term. That was the 3 honorable judges' view out of 5. Thereafter, my lord, the reference says, having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, the doubts have raised, and the issue being a matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench, as may be considered appropriate, to hear and decide the issue arising. We order accordingly. Otherwise, the
Squarely covers. And this judgment in even courtroom exchanges also, it applies.
yes, my lord. Though our privileges are, my lord, much lower threshold, my lord, but they are not, my lord, the legislators, whether in parliament or legislature, they are not even amenable to contempt jurisdiction. But that's not the question here. Its question is of a criminal offence.
So if your lordship would consider, your lordship would.
Or only the question is whether it is only the act within the house or the entire scope of the act has to be considered.
I'll say, yeah, the ladyship is absolute.
Immunity has to be given to the entire act.
Yes.
or only to what happens on the floor of the house?
I commit an offense outside and the result is in the within the house. That is one. So one issue. I am not raising this question, but I am flagging it for your lordship's consideration. So as my lords have rightly said, this is as such covered by P. Narasimha Rao, which is a five-judge bench judgment. And the court felt that considering the seriousness, this needs revisiting. So whether that revisiting would be permissible or possible or at least effective in this combination. Because five-judge view, my lord, your lordships may perhaps, my lord, feel bound by. Though it is 3-2, but now in view of the recent
judgment, you
recent
can't raise
judgment, my
that
lord, that
you can't know the
numerical
numbers,
it can't go by the numerical strength.
It's a judgment of the bench.
It is a bench, yes, the judgment of the bench.
Let us see on that.
15. Even 9.
This is an issue, my lord, which your lordship will have to examine. Hardeep Singh's judgment is already there. According to me, my case is covered by Hardeep's.
This needs, but this is interpretation of section 319 of the Code of Criminal Procedure. This is my question.
The other side said that it has to be interpreted. And I said that two judge bench.
At what stage you can invoke 319? That is the
Correct,
question.
That's the question.
When the judgment is reserved, when the case is reserved for judgment, can you invoke thereafter?
Yes,
That is
yes,
the only
yes.
point.
One and the last issue which the honorable bench referred was, what are the ingredients to be taken into consideration? Hardeep Singh goes on that also. Even that is answered. Dispute that, the attorney and the solicitor, or even the additional solicitor. But allowing that application, I am opposing.
Why?
The reason is, this is a case under the NDPS Act. It is a case which is by the Punjab government. The parties to the case are only the Punjab government and the accused, or the complainant can come. The Union of India cannot be a party. Your lordship may let that application be, my lord, your lordship, without allowing it. They can address if they want. I cannot stop even otherwise the learned solicitor from addressing. But if your lordship wants to make an order, then please issue a notice. I will file my reply and your lordship may take a view.
But the limited point is this, my lord. When your lordships
Reason is, the real reason is, on the basis of this, they have started PMLA proceedings against you. Now, in those PMLA proceedings, they are using the same allegations. So this is a roundabout way of protecting their PMLA proceedings. They have said so in the application also. So this is not an application that somebody wants to genuinely come and help your lordships in interpreting the provisions of law. This is a interest in this litigation. And that interest in this litigation is irrelevant in my respectful submission for the purpose of this matter before your lordships.
But one thing is certain, on account of the pendency of this case, there may be large number of cases pending. in the
not
country.
only
Yes.
this, I'll just respond in 2 minutes. Your lordships are not examining the facts of this case. So there is no question of my opposing or supporting him. When your lordships are examining a central statute, that is Criminal Procedure Code, the presence of the central government would really be necessary. That's all I'm saying.
Your lordship may allow him to intervene vis-a-vis
This is the matter on 15th now.
Only one more request. No, there is one matter tag 504.4. It's a bail matter, my lord. It may be D-tagged. It may go before a regular bail. This 319 question doesn't arise. Of course, we said that it is.
Who's the petitioner?
I am the petitioner.
My client?
No,
Is the
no.
respondent? No.
No, we said that similar
Bail can go before the regular.
504.4 may go before a regular bail. But this 319 question doesn't arise.
Yes.
Under D type sanction listed before the.
This is challenging your bail.
All right.
319 is not.
That is delisted, it will go before the appropriate.
But actually, the High Court has granted me bail. I didn't appear. I was just reading their impediment application yesterday evening. In that, they have mentioned, High Court has granted me bail because the High Court says since this matter is pending, they can't finally decide, take a view. So 504 can let it come on 15 November. Your Lordship may take it after this is decided, because then if it goes away, then again I will.
Some date may be given. I am not saying. Some date may be given.
Look, let it remain tagged on that day when your Lordship answers this question.
You already have been granted bail.
I have.
It is my challenge to the bail.
They are
section.
challenging that.
So let it be considered independently. whether
That's
the-
all, my lord. I'm saying.
Let it go.
Section
No, no.
319 doesn't.
All right, all right. Next.
Why do you want to, the constitution bench to decide whether the bail is rightly granted
No,
or
no,
not?
I'm only saying it should come after this,
All
after your
right.
Lord.
Wait, next case.
The next case is under the Prevention of Corruption Act.
4.1 also there is a tag matter with these matters. Not just a suggestion, not other
15
benches
no,
in
sorry,
these group
15
matters are
November.
considering not to apply written submission in advance by parties before assisting the court for better assistance. As your lordship was listed on 15 November, any parties to make submissions can circulate to submission in advance, as well as your lordship may consider appointing one of the.
You keep that ready on that day, let us see, right?
Just another suggestion. One of the candidates on record are we considered to be appointed as a nodal officer for purpose of compiling everything and placing before your lordship for your lordship's benefit. That may also be considered.
All right, no. For this case, not necessary. What is?
All right.
See, there is no dispute on facts. The only question is whether 319 can be invoked after judgment is being reserved. That is a legal question. That's all.
That's illegal. Facts are not. And your
Facts are
lordship,
not.
even if they are in
And
dispute,
facts we are not going to examine also.
yeah, even if we raise, your lordship would not examine
We
facts.
will not examine the facts.
Great.
Next case.
Lord, 505, my lord, is a case under the Prevention of Corruption Act.
Yes.
Here, my lord, the complainant, the bribe giver, died. So there is no question of, my lord, proving the illegal demand being made by him. So whether that can be inferred in the trial, because there is nobody who will prove that. So this may, my lord,
No, is it the only way to prove, or is there any other way to?
that's the question frame, my lord.
The
That's
moment he dies, criminal case goes, is it?
it cannot, unless the accused dies. The question,
Accused dies.
There are two conflicting views, not so free.
True, we have seen that,
yes, but that's the question. My lord, very precisely, that's the question. Is it the only way, or there can be other ways of proving?
Bhanumati's judgment,
Yes.
of order of reference, we have seen that.
Whether there's an inferential deduction that can be drawn.
On,
Inferential deduction, whether it can be drawn.
on any other evidence which is on record.
That's
Yes, but inference may perhaps not be a correct expression, because in a criminal trial for punishing someone, you can't do it on inference, but any other mode of proving, that's
Whether a finding can be given with other evidence.
other evidence on record. No, you can't
Or
infer.
simply,
Yes.
the complainant dies, the case has to go.
That can never.
No, not just the death of
A, B, and C comes and deposes that yes, it was taken in my presence, but the complainant turns hostile. What would be the powers of the court to actually?
whether the demand has been proved or only.
Correct.
We will fix it again on 15th, right? We will examine on.
My
Please.
lord, item 505.5, my lord,
Hmm.
it needs to be de-tagged because the primary complainant in this case present across the case, cross-examine everything has been happened, and trial court has convicted, but high court has acquitted us. So it has been wrongly tagged, my lord, if it can be de-tagged, my lord.
It will
Because
have to wait.
This question has no bearing, is it?
No bearing, my lord. It's IA number 62150, my lord, because primary complainant is there. Entire process, PW11 in this case, So there is no question, none availability.
Complainant is available, was available.
My lord, cross-examined everything available.
Then I think we have to retype, transfer. Give that number and speak before the appropriate time.
Duryodhan Sahu.
All, that's all?
Please, sir.
Grateful.
Grateful to you. 12th of October, rest
These
15th
cases will be on 15th
November.
November.